I have a 4 o'clock scheduled with Judge Schwall by video, so I can, whatever is the court's pleasure.
Well, we'll definitely get to you before Judge Schwall, but you tell us. Ms. Lubinsky, do you have any idea?
I think we are very close to a resolution.
Wait a minute. I know what to do now.
Oh, sorry.
We'll definitely get to you before Judge Schwall. I know what to do. You tell. Okay. I'm so proud.
Yay!
I learned so much yesterday after my 3rd hissy fit. So we are now on YouTube. And what'd you say, Ms. Lubinsky? What's a good estimate?
It depends. If we're going ahead with a plea, we shouldn't be that long.
Are we doing a plea?
Your Honor, we've been talking about a plea agreement. We haven't quite reached an agreement yet. So I don't know how Ms. Lubinsky wants to proceed.
Well, we had you on for a motion to dismiss, which I was prepared to hear, but if you need more time, or if you want us to take up the other case first, or if you want a breakout room, you just tell us what to do.
Hold on just a second.
Okay. Mr. Wright, don't go anywhere.
I'm not going anywhere, Judge.
Okay. Mr. Ruckers, everything going okay?
Yes, ma'am. Yes,
Okay.
Your Honor.
Yes, ma'am was fine.
Mm-hmm.
Your Honor, the only issue I was currently experiencing with the plea that Jenny and I have been talking about is I was trying to get in contact with one of the victims in the case, and I wasn't able to do that yet. So that was my hesitation on the plea agreement.
Ms. Lubinsky, what would you like to do? Would you like to go forward and let me hear the motion to dismiss and just hold it? Or do you want to save your energy and strength and come back some other day for the motion if you can't get it resolved?
We can try to get dismissed if we can.
Okay. All right. All right. Let's proceed with the motion to dismiss.
I think it might be helpful for Mr. You tell me what you want to do, and I am open to anything.
Lauren, sorry, Lindsay, when would you be able to have an answer? Or
I mean, like I said, I left a message, and I mean, I could either try to reach out to her again now, or I can work with Ms. White to get hold of the victim in the case. I just would like to speak with her before we proceed with any kind of plea so that they are aware of what's going on. It's particularly the victim in the second case of Mr. Ruckers has on the calendar. I mean, I'm fine to reset it for another day this week, or if you want to proceed with the motion, I'm fine with what you want to do.
let me proceed with the motion then.
All right. Okay, Samantha, we're back on the record then. This is the state of Georgia versus Mr. Jamarius Ruckers. Again, just to, in the risk of being repetitive, these are 18 SC 162557 and 18 SC 162992. Today is October 27th, 2020. This matter appears on today's calendar via the Zoom teleconference platform. Everyone in this case is appearing via Zoom, including the defendant, Mr. Ruckers. The case is also, or this particular motion hearing is being broadcast on the court's YouTube live stream channel. The purpose of that is to ensure that the public's business remains open and accessible to it. And anyone who wanted to sign on to the YouTube channel could have done so. So we have done that. We're all appearing via Zoom. We're on for motions to dismiss filed on behalf of Mr. Ruckers in these cases. And at this point, I'm going to ask the state if it has any questions of Mr. Ruckers about his appearing via Zoom rather than his personal appearance in the courtroom.
Thank you, Your Honor. Good afternoon, Mr. Ruckers. My
Good
name is
afternoon.
Lindsay McClure. I'm the Assistant District Attorney for the state. Did your attorney talk to you about this hearing today and that it would be via Zoom?
Yes,
Do you waive your presence to be physically here in the courtroom for this hearing?
yes,
Okay, so you want to proceed via Zoom?
yes,
Okay, thank you, Your Honor.
All right, at that being the case, Ms. Lubinsky, I believe these are your motions. Are there motions in both cases or just the one?
There are motions in both cases.
All right, if
And,
you'd like to
Your
proceed.
Honor, both motions are fairly similar and they're based on the same thing, outstanding discovery.
All right,
We are missing discovery in both these cases, both of which are more than 2 years old. In position 2 on the calendar, which is 18 SC 162992, I have virtually nothing from the state. I have a basic police report and little else. Your Honor, and initially, when this case was at its pre-indictment stage, one of the reasons that Mr. Ruckers was granted a bond on that case at the time was that the state simply couldn't get the witness, who is a police officer from East Point, to court long enough to actually get her to testify at a preliminary hearing. Presumably, she came to court long enough to testify at a grand jury hearing, but that's as far as that went. Both these cases are 100% officer driven. In position 1, yes, there are other complaining witnesses, but the main complaining witness and what this case is all about is officer driven, and position 2 is entirely officer driven. And Your Honor, we are more than 2 years down the line and we cannot get basic discovery which should be in the possession of the state. And if it's not in the possession of the state, in position 2, it is in the possession of the East Point Police Department. In position 1, in the possession of the Atlanta Police Department. These are organs of the state. It is their obligation to comply with requests. And for 2 years, we have not received everything we need. And Your Honor, when you're trying to investigate and prepare a case for trial, the longer it takes to get the information you need, the less likely you are to be able to prepare a proper defense, the less likely you are to be able to locate the witnesses and follow up on whatever outstanding information there is. And Your Honor, there's no reason why we should be in this position other than, Your Honor, and I say it's bad faith on the part of the police department, and they're an organ of the state. And under those circumstances, I'm asking that both cases be dismissed.
Before I turn it over to the state, let me just ask you a couple of questions, Ms. Lubinsky, because of course, there was in addition to my notes, which were very instructive, there's also a filed transcript of the hearing we had in this matter back either the summer of 2019 or maybe a little bit earlier in 2019. And that was exactly the issue. The issue was there had been a discovery order, there had been a follow-up discovery order, there had been a motion to compel, there had been a follow-up motion to compel, finally resulting in a show cause order issued by this court to the one particular police officer who came and stated that he was a victim.
Yes.
And that he had not been able to secure all of the discovery. And so don't think, number one, that this is the first I'm hearing of all of this. I've been involved in it since July 1st, 2018, and don't think that I don't share your frustration. I mean, the frustration, some of it I didn't even understand when I first began as to where evidence comes from. So I agree with you. It's officer driven. I agree with you. The officers seem to be the ones not only who'd be most highly motivated, but who have possession of the material that we seek. The one thing that I want to push you on, Ms. Lubinsky, and I really am interested in your response, is I've looked at exactly what I just described, even more so than I just described. And yet I found a very clear sentence in that transcript in which I found that it was not in bad faith. So why is it in bad faith now?
Amongst other things.
And if it's the passage of time, then maybe it's just the passage of time.
We're almost a year down the line.
It's not a bad answer.
In fact, I think we're over a year down the line. If that's the hearing in which Officer Sparks testified.
That hearing, well, it was the transcript was filed in May.
But I think the hearing itself.
Probably a little earlier, yeah.
So it's a long time ago, and we're still a little better than we were then, but we're still looking for documentation, for recordings, for things that we should have and don't have. One of them, for example, is the radio traffic and transmission from the officer who is talking to his colleagues while he is supposedly chasing this vehicle and being shot at. And that recording has apparently been disposed of. Because it was not retained by the police. And that, I believe, constitutes bad faith.
Was that raised? I don't remember that particular, I don't remember that in the transcript.
I asked repeatedly for radio traffic and transmissions. And a while ago, I think it was Miss Macaulay who told me that that recording was no longer in existence.
Gone?
Yes.
Okay.
So, Your Honor, it's things like that that make it bad faith, because I asked for that a very long time ago, and it should have been.
But yeah, okay, so I'll let.
Okay, go ahead.
It should have been preserved, and the failure to preserve it under these circumstances can only constitute bad faith.
All right, anything further before I hear from the state? And I'll give you an
From the
opportunity to
defense.
okay, I'll give you an opportunity to respond. Ms. McClure?
Yes, Your Honor, thank you. So, Your Honor, while the state acknowledges that this case is a couple of years old and there has been some issues with discovery in this case, the state, Ms. Lubinsky has not proven that the state has acted in bad faith, Your Honor. The state, even Ms. Lubinsky cites this in her motion, the state at numerous points throughout when the state even held, when the court held the hearing on August 15th, 2019, where Mr. Starks was present, the state did turn over discovery after that hearing, I believe on August 22nd. And previous to that, last year in June, the state turned over more evidence after the court entered a scheduling order. Ms. McCauley has sent numerous emails, as well as myself, trying to obtain the evidence in this case from both College Park and Atlanta Police Department. Even at one point regarding the radio transmission request, Lauren was sent an email back. They rejected her subpoena from Open Records, and we sent our investigator to try to locate it, and that's how we came across that it no longer existed. The state has made diligent efforts, and I believe as well that we shared those communications with Ms. Lubinsky about that. The state has made numerous diligent efforts to try to obtain evidence in this case, and that in bad faith, would mean that we have the evidence and we're deliberately hiding it from Ms. Lubinsky, and we are not. That's what it sounds like she's saying to me. I'm not saying that that's what she's arguing. But the state does not have that in their possession. They are trying to diligently get it in their possession. But even if the court were to find that, the defendant has been prejudiced in this case, the proper remedy would not be dismissal. And exclusion is a harsh remedy and should only be used, like I said, if the defense has proven that he has been prejudiced and that the state acted in bad faith. I don't believe, granted, the passage of time, Ms. Lubinsky talked about that. The passage of time does not necessarily indicate bad faith on the state's part. That the state is very frustrated itself with trying to obtain evidence in this case. And we have made numerous efforts to get discovery to the defense through emails and subpoenas and phone conversations. And if the state were acting in bad faith, then we wouldn't have acted that way from the get-go in this case. I feel the defense's frustration. I have the frustration too. I'm currently working diligently to get the evidence in this case, and we're working to get it resolved. But Your Honor, the state would argue that defense has not met its burden of showing that the state has acted in bad faith. The passage of time does not meet the burden that is required of the defense in this case. We have, once again, Your Honor, we have made diligent efforts in this case to try to get the evidence to the defense, and we have numerous email communications and phone communications regarding this case. So, Your Honor, I would argue that a dismissal of this case is improper.
Okay. Well, I don't think I need to restate the obvious, but if I were to restate the obvious would be is that it's not the court and the state and the defendant versus the bad guy, the police department. You are the police department. I mean, at any rate, the frustration was there over a year ago, the frustration on the part of the court. And I'm not completely sure I ever tagged the DA with it. I mean, I think that was the whole point of hauling the officer into court. And then I don't think he did that much good for the side. But I am going to tell you at this point, what has transpired, whether it's the erosion of evidence, I'm not going to use the word spoliation, but missing evidence, whatever it is, what I'm faced with today, I think, is not a presentation of more missing evidence. I think it's a presentation of the passage of time. And the passage of time at this point cannot be taken in a vacuum without also exploring the COVID portion of this, which has essentially put a lot of things on pause. So I want to say this, Mr. Ruckers being in a t-shirt today rather than a prison uniform or a jail uniform is not something that screams and yells, well, gosh, what are y'all all worried about? He's out. I mean, that's not freedom. That's some pretrial release, but that's not freedom. And he still remains subject to a lot of restraint. I would think that the police would want to see this matter over. At this point, without prejudice, I am denying the motion to dismiss. But if we don't get this, if we don't get this resolved some way, I think we really are looking at being more specific about what evidence is in and what evidence is out. And that I intend to do way before juries come back. Okay.
Oh, please.
All right. Mr. Ruckers, it's good to see you. You're taking care of yourself, correct?
Yes.
Okay. All right.
Sure.
It's good to see you, and I hope things progress. Thanks.
All right. Thank you.
Okay.
Judge, are we putting any time constraints on this other than,
Sure. What do you want?
I don't know, maybe 2 weeks max? Am I being unreasonable?
Ms. McClure, what is your response? I mean, I don't think things are going to mysteriously start appearing. And if you have said, and Samantha, can we remain on the record? Because one thing that I heard today that I had not heard, because I think it may have been a conversation between Ms. Levinsky and Ms. McCauley, who's sitting right there, is that the transmission, the in progress transmission, I'll call it, is never going to be found. And I think that's new. And if that is something that we either need to put on the record or otherwise explore, what I was talking about earlier is getting to the point where we say, this is in, this is out, this is in, this is out. And I don't know that we can do that in 2 weeks, honestly, but I think we should be able to do it in a month.
Okay.
Yes, Your Honor.
Okay. All right. Thanks again.
Thank you, Your Honor.
Thank you. Okay, we now have Mr. Jones, and if we're ready to start that, when you're ready, Mr. Wright, we didn't keep you too long.
No, not at all, Your Honor.
Let me get one thing. Well, I'm not gonna be able to find it. Shoot. Okay. All right, are y'all ready to proceed?
Yes, Your Honor.
The second case or the third case, second person on the calendar for this afternoon is the state of Georgia versus Leon Jones. This is 17 SC 154313. Today is October the 27th, 2020. We are all appearing via the Zoom teleconference platform, and I'll get to the defendant in one moment. We're appearing via the Zoom teleconference platform. We are on the court's YouTube live stream channel. And Mr. Jones is not present. So one of the things that we would have to address pretty quickly here is whether Mr. Jones waives his right to be present, number one, in the courtroom, and then certainly otherwise by Zoom. But he's not here. This is, and let me read the title. This is because it's got got an interesting title. This is a demand for acquittal based on violation of constitutional speedy trial rights. And this was filed on May the 19th, 2020. The most recent appearance of this case was in I believe a bond. No, it was
It was a bond.
the bond, because the guilty plea had occurred
In December.
Okay, thank you. Ms.
Mhm.
McCauley is present and helping. But I think that we are hearing this demand for acquittal on the basis of speedy trial rights. And I'm first going, Ms. McCauley, are you handling this for the state?
Yes, Your Honor, I'll be handling this for the state.
Okay, do you mind asking Mr. Wright or any questions you might want to ask with regard to Mr. Jones not being present?
Yes. Mr. Wright, have you had an opportunity to discuss today's motion with your client, Leon Jones?
I have.
And did those discussions occur at the jail, over the phone, or via video conference?
Both in person at the jail as well as over the phone.
And did you obtain your client's permission to handle this proceeding via Zoom without his presence?
Yes, both this as well as the bond hearing. We discussed specifically that I would file, and proceeding on those may require his waiver of his physical presence, and he authorized both.
Great. Your Honor, the state is satisfied the defendant has properly waived his presence, and I think we're ready to proceed.
Okay, thank you, Ms. McCauley. Mr. Wright?
Your Honor, and I guess to some extent it intertwines with arguments you've heard previously at the bond hearing, but we have filed this, and the court bears with me. I'm going to try to state a lot of dates. This case has a lot of history to it. The incident date, I believe, goes back to September 8th of 2017. My client is charged, of course, with various offenses stemming from an alleged aggravated assault of the victims. He was in custody until he was granted bond February 20th of 2018. He was out on bond for about a year, and on February 20th, 2019, went back into custody as his bond was revoked. My client ultimately had received a new charge, a misdemeanor, in 2019, and that was the concern the court had at that time, which ultimately caused him to go back in custody. He has been in custody ever since. My calculations is approximately 165 days leading up to the point where he went back into custody. And I'll give the court two numbers. A total, including from February 20th, 2019 to present, a total of 770 days. If we take out COVID, if the court is inclined to exclude the COVID time, going back to March 1st, 2020 of this year, that would lower that 770 to 540 days. Based on the judicial emergency, I would imagine the COVID time would not count in the amount of time for the court's first consideration in terms of the length of time that it has taken for Mr. Jones to obtain a trial. Your Honor, but for that reason, he has been in a substantial period of time without bond. He did assert his speedy trial rights, first by statutory speedy on December 6, 2017. He tried again, or at least to have a hearing on that, January 22nd, 2018, again on February 20th, 2018. It was not heard, I don't believe, but that ultimately the court specifically again gave him leave for an out of time statutory speedy on February 20th, 2018. That was withdrawn March 2nd, 2018. New speedy was filed April 25th, 2018, and that also was withdrawn June 8th, 2018. I suspect that those 2018 speedy trials and withdrawals also happened to be contemporaneous to when he was ultimately given a bond by the court on February 20th, 2018. Since then, this, I believe, is the next, I guess, in the succession of speedy trial demands, this being a constitutional speedy, which I believe is governed by Barker versus Wingo. The factors the court should consider first is the length of delay, which is why I set forth just how long it has been since Mr. Jones has been waiting to receive a jury trial on this case. Second, I don't believe the state will be able to put forth any justifiable reasons for the delay. Third, he has been asserting his rights for a speedy trial, as the docket is replete with instances in which he's made that assertion, which I think then simply brings us to the fourth in terms of the prejudice. This is a case where there is a question as to whether or not the victims or witnesses will in fact be available to testify at trial. While early on there may have been some concerns as to their abilities based on alleged injuries, now I think we're at a point where we're several years sort of down the road. I'm not sure if, based on what the state will present, whether there are any circumstances or things which have now caused their victims to be even less likely to appear in court and capable of testifying in this case, and or whether other witnesses are still going to be capable of being brought in to testify at this case. It's one thing if my client had been out on custody on bond waiting this substantial period of time, but because he is continues to be incarcerated, he has no ability to help with his defense from a practical standpoint. It's very challenging, of course, especially with COVID, going to the jail, going through stuff with him in that regards. We don't have a good sense of whether we have victims capable of testifying this extended period of time now away from the incident date. So again, we would submit respectfully to the court that we have shown that there is a undue delay in this case, which would constitute or at least justify the court going forward into the other factors set forth in Barker v. Wingo that we have set forth that.
I'm sorry, you said Barker and who?
Barker v. Wingo. And I can give the full site, which is 407 US 514. It's a 1972 case, and that is, I also will give the Georgia case, Ruffin v. State, 284 Georgia 52, a 2008 case. So at this point, we would at least say that we've set forth the primary consideration of the length of the delay without just cause. There's a clear record of his assertion of the right, and we contend he has been prejudiced and continues to be prejudiced by this substantial delay where he sits without bond.
Before I guess this is going to be Ms. McCauley, but before the state responds, let me ask you one thing, Mr. Wright. I thought this was a two-prong inquiry that first, or a threshold inquiry. First, has there been a presumptive delay based on time?
Well,
you don't get to the 4-part test until you determine that this has just been too long.
And that is correct, Your Honor. And I guess I sort of glossed over that, but I do think we've reached that point where and again, I guess with and without COVID, we're 2 years plus in overall time since the incident date at the 770 mark. I guess with the COVID mark, I would say we're still short of 2 years, but from a practical standpoint of him remaining in custody for all this time, I would suggest respectfully to the court that I think we have reached that point where there is a presumptive, we've reached that presumptive mark. Even before COVID started, we're talking about September 8th, 2017 until March 1st, 2020. I mean, we're almost at a 3-year mark, well, 2.5 years mark from incident date to the beginning of the COVID, I guess, a judicial emergency. So I think that would constitute enough to show that we've reached that threshold.
Okay. All right. Thank you, Mr. Wright. Ms. McCauley?
Yes, Your Honor. So just to educate both the court and counsel, there is case law that states that any delay beyond 12 months is considered a presumptive delay, and then the court should go in to consider the factors. That's actually what the case law says. So I'll just go straight into the factors. The length of delay, I would argue to the court, and these are intertwined, the length of delay is largely due to COVID. This case was ripe for trial right before COVID. And I believe the court was in the process of scheduling it for trial right before the judicial emergency took place on March 13th of 2020, or March 17th of 2020. That length of delay is actually largely contributed to by the defense. He filed a speedy trial demand in December of 2017. That was withdrawn when he obtained a bond. The speedy trial demand was then refiled and given leave to file an out-of-time speedy in April 25th of 2018, and then that speedy trial demand was subsequently withdrawn. I don't think that it is unreasonable for the state to proffer to this court that filing a speedy trial demand is often a tactical move for a defense attorney to obtain bond for his or her client. In this instance, it certainly was a way for defense counsel to manipulate the court into granting their client a bond, and to also manipulate the state into consenting to a bond. The defendant was rearrested on a pretrial bench warrant because he picked up a new felony case. It was not a misdemeanor case. It's a felony case. I believe it's before this court. It's a 19 SC case for terroristic threats, which is why he was forfeited on his pretrial bench warrant. It was not a misdemeanor. And then subsequent to that, Your Honor, we were scheduled for trial on July 19th of 2019. The state and defense requested a continuance, or the state requested a continuance to obtain out-of-state witnesses. As the court is aware, there's a witness in California, there is a witness in Houston, Texas, there is a witness in New York that all need to be served via interstate compact, which does require 30 days by statute. The court then set this case down for trial in November of 2019. The state provided additional discovery, which, if the court will recall, during the discovery motion hearing, which after it was served on defense counsel sought to exclude it, it was revealed the defense counsel had been in possession of that discovery since 2017. And they requested a continuance because they wanted to obtain their own expert witness to review those records that they had been in possession of. To date, Your Honor, the defense has not served notice on the state of any expert witness that has been obtained, or any expert witness that has produced a similar report to counter that provided by the state. And that report was served back in October of 2019. And again, that was discovery that defense was already in possession of. So based on those delays, Your Honor, it would actually be on the defendant that he has contributed to the reasons for delay as to why this case has not been brought to trial, with the exception of the state requesting the 30-day leave to allow them to procure their out-of-state witnesses, which is provided for by statute. As to the assertion of his right to a speedy trial, the defendant has asserted his right twice, and he has withdrawn that right twice. And then the defendant chose to get arrested a second time in violation of his bond. So based on that, he has withdrawn his right and he has used it, and the state's position is he is attempting to use this proceeding as a weapon to obtain a bond and to intimidate the court into providing him a bond. As to prejudice to the defendant, the delay in this case has actually been to the defendant's benefit. This particular case is extremely gruesome. As defense counsel is very much aware, one of the victims, Maury James, Susan James, named in the indictment, has deteriorated significantly physically throughout the term of when the case is indicted and up to present day. And she continues to deteriorate significantly. As the defendant is aware, one of the witnesses left the state out of fear for the defendant. She's now currently in Houston. And while the state, we have been in touch with her, we do know where she is, and we will produce her for trial. And as the defendant is aware, the other witness in this case, Ms. Taylor Sasser, was located in California. We have been able to speak with her relatives, and we are very encouraged that we will be able to produce her for trial. The other witnesses are mostly professional witnesses and police officers. There is a medical professional who is in New York that will need to be served, but the state does not anticipate any difficulties with producing those individuals.
I thought somebody was on the last bond hearing.
That was Miss James. That was the victim, Miss James.
Okay.
And so, Your Honor, we would ask the court to deny the defendant's motion, finding that there has not been a delay that can be attributed to the state. The court does have wide discretion, which will only be challenged for abuse of that discretion in granting or denying a defendant's constitutional speedy request or demand.
Okay, thank you. Mr. Wright?
Your Honor, in response, one, in all due respect to counsel, from my reading of the history, as the court's aware, I came into the case much later than much of the history of the case, but that the reason he went back into custody was in fact the misdemeanor case. The terroristic threats case, I believe, did not come up till July of 2019. And I believe he was already back in custody. And I'm just looking on the order the court issued in July, where it was being discussed that the misdemeanor of February 20 of 2019 was in fact the basis for the concern and his rearrest, and then the revocation, which caused him to continue to be in custody. Secondly, the right being asserted previously from 2017 to 18 was a statutory speedy trial right, which is a different creature of Georgia statute as opposed to a constitutional speedy, which is being asserted in this instance, which I think there are different considerations as such. I'm not sure we simply say because of a statutory speedy that may have gone forward or may have been withdrawn, that somehow negates a defendant's ability to still argue a constitutional speedy trial demand, which is what is before us now. So I don't think the fact that he was trying to assert a speedy trial right previously in some form or fashion immediately means he somehow negates his ability after a substantial passing of time since that activity to not be able to file a constitutional speedy. The state seems to some degree concede, and while it is unfortunate that there does seem to be a deterioration and possibly evidence, whether to its benefit or not, I don't think is the consideration, but just whether or not there is some evidence which may no longer be able to go forward or be presented at a trial for him to receive a full and fair trial appears to be what's starting to happen as we go longer and longer without him being able to get a trial. So I would respectfully ask this court to consider granting this motion from a constitutional speedy standpoint.
All right, thank you. I do want to just say that from my reading of the case law and specifically paying close attention to and being aware of this record, that it does seem incumbent upon me from all that I've read to actually state the court's findings for the record. And so I am denying the motion, and I am doing it for the following reasons. Number one, with regard to the length of time, whether this was a result of, I mean, Ms. McCauley seems to suggest that it was some gamesmanship's not the right word, but let me just say strategy, whether it was the result of some strategy on the part of the defendant, that the original statutory speedies all occurred within approximately a year. Of course, it was under the docket at that time of another judge. And so insofar as exactly how those matters played off each other, I can't be as certain as I could as if they had happened in front of me, but it does not appear as though the defendant himself felt ready to go forward under the speedies that he was filing and withdrawing. So I don't know that particular part of the history counts in favor of the defendant. With regard to passage of time, particularly under this court's docket, this case comes up a lot. And it comes up for various reasons, some of which have been motions hearings, some of which have been trial calendars and either setting it for trial. The state says it asked for continuance for the out-of-state compact issues, and I'll take that at face value because I know orders were issued. But I would say that from the court standpoint, we've been trying to get this case tried and resolved. So I do not believe that there has by any means been state action that has prevented Mr. Jones from getting his day in court. With regard to the question of the evidence and whether there's prejudice or not prejudice, I guess there are plenty of cases where victims can't testify. And that doesn't mean that things like murder cases don't go forward. There's evidence here to convince a jury. There's certainly been, I don't think, any motion on the basis of the insufficiency of the evidence. So I don't think that is a compelling reason. Let's see. Prejudice to the defendant. We talked about that twice. What was the third? The third thing was the assertion of his right to speedy trial. I think we've discussed that.
Yes, Judge.
Reasons for the delay and prejudice to the defendant. So I don't believe that any of those issues are met in this case. And finally, I do think we have to put on the record, I don't think COVID prevents someone in custody from feeling any less in custody. I will certainly give you, Mr. Wright, that if anything, it's been more frustrating not knowing when the end is going to come, as it's certainly been frustrating for all of us. I hope we do have a pathway forward in getting cases up again and trying them in front of juries. And again, I'm not minimizing the fact that a whole chunk of time has disappeared. I do think that under the court's emergency orders, speedy trials, perhaps statutory, I'll give you that, but certainly the rationale, I think, would apply to constitutional demands as well. So I'm denying it for those reasons. Hopefully I had put enough on the record. I'm very familiar with the case. I'd love to get it resolved. I'm sure the state would. I'm sure the alleged victims would, and I would consider it because not only because of its age, but because of its the fact that I did. We all know a lot about it. I would hope it'd be pretty close to the top.
Yes, Judge.
Okay.
Judge and Mr. Wright, correct me if I'm wrong. Do we need a written order?
I believe probably so.
Okay.
That sounds like a good Ms. McClure job for a first draft.
Sure. Lindsay, I'll help you.
Okay.
Okay.
Well, let's circulate it and we'll all participate and we'll get it entered.
Okay.
Judges, that concludes my business before the court today. May I be excused?
Sure. It's good seeing you, Mr. Wright.
Good to see you, Judge. Take care.
Okay, thank you. All right. I think that's all of our cases on for this afternoon. And anything else?
Nothing. Thanks, Your Honor.
Okay.